The Supreme Court just denied our petition to hear our Illinois assault weapons ban case. But don't get discouraged. This isn't the end. In fact, there's now more of a chance of a future victory in this case. And today, we're going to dive into the fight over Illinois' tyrannical assault weapon and standard capacity magazine ban. I'm Phil, and you're watching Law and Ammo. On today's episode of Law and Ammo, we're going to break down exactly what's going on with GOA's anti-assault weapons ban lawsuit. This all began in January of 2023. GOA's team of state and local lobbyists were unable to prevent the state legislature from passing the totally misnamed Protect Illinois Communities Act. Governor Pritzker signed an unconstitutional assault weapons ban that imposed really sweeping restrictions and outright bans on the sale, purchase, manufacture, delivery, importation, and even possession of many firearms, magazines, attachments, stocks, and grips. Basically, this was a nightmare for gun owners. So we gathered together a group of gun stores, which the courts called Federal Firearms Licensees of Illinois, and a few other plaintiffs, and filed our case, FFLs of Illinois v. Pritzker. For strategic reasons, GOA filed our lawsuit in federal court, specifically the 7th Circuit, down in the Southern District of Illinois. In our lawsuit, we asked the courts to declare the Firearms Ban Act to be an unconstitutional infringement of the civil rights of law-abiding residents of the state of Illinois and the United States. In our arguments, we went point by point explaining why the state could not ban any bearable arms or attachments to firearms under the Second Amendment, and we refused to compromise away anything in our legal arguments. At the same time, other lawsuits were filed in the Southern District of Illinois by NSSF, FPC, and SAF, and some gun owners. A couple other lawsuits were filed in the Northern District of Illinois as well, but we'll get to that a little later. Because we all filed similar cases, the court system consolidated all our cases before a single judge, Judge Stephen Patrick McGlynn, a Donald Trump appointee from 2020. Now, when we all went to court, our attorneys basically had to take turns arguing alongside FPC, SAF, and NSSF against the Attorney General of Illinois, Kwame Raoul. So to help you keep track, our case, FFL of Illinois v. Pritzker, and several other cases became part of Barnett v. Raoul. And at that point, we all decided to fight for a motion for preliminary injunction, which would have prevented the state of Illinois from enforcing its assault weapons ban while we litigated the case. In order to win this injunction, GOA had to prove to the judge that we were likely to succeed on the merits of our case. And so what that means is that the judge had to think it was likely that we would get the assault weapons ban struck down as unconstitutional. And so our attorneys went to court, and Everytown for Gun Safety filed an amicus brief in support of the assault weapons ban on behalf of the billionaire Michael Bloomberg. And then in April, we got a ruling. Judge McGlynn ruled in our favor and granted the preliminary injunction, which would have stopped the assault weapons ban from being enforced. He rejected the Illinois anti-gunners' arguments that accessories not necessary to the function of a firearm are not arms protected by the Second Amendment. Instead, he recognized that to have a right to possess firearms for self-defense, you have to have the right to effectively load ammunition into your firearm. Go figure. He said that Americans have a right to maintain proficiency in firearm use through training, practice, and the use of accessories like pistol grips, thumbhole stocks, and flash suppressors. That's all very based and true. As a result, the court determined that magazines are arms, as used in the plain text of the Second Amendment. He also said that the ban on pistol braces interferes with the meaningful exercise of the Second Amendment rights for individuals with disabilities, and that accessories that aid you in accuracy may be considered arms and are presumptively protected by the Second Amendment. So this victory had some pretty far-reaching implications, but the anti-gunners weren't going to let that rest. Illinois immediately ran to daddy and requested an emergency stay from the 7th Circuit to block the preliminary injunction that GOA just won. And while it had taken GOA 4 months to get the assault weapons ban enjoined, it only took the 7th Circuit 2 days to block our victory. The anti-gunners on the 7th Circuit blocked our preliminary injunction, and we were forced back into the slow legal process to appeal it. Meanwhile, something else was going on in the Northern District of Illinois, where the National Association for Gun Rights and some other gun owners had filed their own 2 cases. Unfortunately, a George W. Bush-appointed judge ruled against the National Association for Gun Rights, and a Biden-appointed judge ruled against the other case, Herrera v. Raul. So now there were 6 pro-gun lawsuits against the assault weapons ban, 2 up north and 4 of us down south, appealing to the 7th Circuit to get the new gun control blocked. Now, we all got consolidated with the northern cases, and it became known as Bevis v. the City of Naperville. And then things really started to heat up. The anti-gunners started filing their amicus briefs. Attorneys general and other pro-gun groups started filing their amicus briefs. And in June, we were assigned our judges. Judge Frank Easterbrook, a Reagan appointee, Judge Diane Wood, a Clinton appointee, and Judge Michael Brennan, a Trump appointee. When the ruling came on November 23rd, we lost with the Reagan and Clinton appointees ruling against the Second Amendment, and only the Trump judge ruling in our favor. The Second Amendment right of the people to keep and bear arms is not a second-class right. Yet, the state of Illinois and several Illinois municipalities have categorically banned law-abiding citizens from keeping and bearing a sweeping range of firearms and magazines. In a remarkable conclusion, the majority opinion decides that these firearms are not arms under the Second Amendment. Because the banned firearms and magazines warrant constitutional protection, and the government parties have failed to meet their burden to show that their bans are part of the history and tradition of firearms regulations, preliminary injunctions are justified against the enforcement of the challenge laws. I respectfully dissent. Thank you, Judge Brennan, for being such an awesome patriot. Somehow the other judges pulled the old, well, the Second Amendment protects an individual right to keep and bear arms, but, and then they said it was valid to ban guns if they were too military looking. So all 6 of us pro-gun lawsuits decided to do the next best thing and appeal to the full 7th Circuit to get around the 2 anti-gun judges. We filed an appeal to go en banc, which basically means that our case would be heard by the entire court, not just a panel of 3 judges. But the whole court was so anti-gun, they refused to hear our case. And that brings us to today. GOA has filed our appeal to the United States Supreme Court alongside the other lawsuits. In our writ of certiorari, we asked the court to decide whether Illinois' categorical ban on millions of the most commonly owned firearms and ammunition magazines in the nation, including the AR-15, violates the Second Amendment, and we focused on 3 errors by the 7th Circuit. Number 1, we think it's ridiculous that the 7th Circuit distinguishes between scary military firearms and civilian firearms for defense. The first part of the Second Amendment informs part of our founders' intent. They wanted us to form militias for the security of our free state from tyrants and from foreign invaders. Therefore, the Second Amendment protects the same military firearms banned by the 7th Circuit's opinion. Number 2, we argued that the 7th Circuit was wrong to switch the Bruin test around. The test in New York State Rifle and Pistol Association v. Bruin says that to justify a gun control law that regulates conduct that is presumptively covered by the Second Amendment, the government must prove that it fits with the historical tradition of the regulation of firearms that was at the time our country was founded. Instead, the 7th Circuit asked us why we needed AR-15s and, quote, to prove an AR-15 is not useful in military service. And finally, number 3, we argue that the 7th Circuit was wrong to cite examples of police and military being exempted from gun control. That doesn't matter. And what does matter is that our founding fathers intended for us to be as well equipped as the government. The 2-to-1 ruling against us said that both the states and federal government have long contemplated that the military and law enforcement may have access to especially dangerous weapons, and that civilian ownership of those weapons may be restricted. But GOA pointed out that the 7th Circuit never required Illinois to provide relevant historical laws banning commonly owned firearms. Instead, the 7th Circuit lost itself in the weeds of military and police exemptions to various laws in all manner of unrelated contexts, across all manner of irrelevant time periods. But founding era history clearly establishes a tradition contrary to the majority's premise. Indeed, the founders repeatedly sought to ensure the citizenry would be as well equipped as the military. James Madison, Tench Coxe, assuaged anti-federalist concerns of centralized military power by promising that well-armed citizens would provide a sufficient check on despotic ambition. In order to effectuate this purpose, the founders understood that the citizen militia had to be as well equipped as the standard infantrymen. The glaring absence of founding-era restrictions distinguishing civilian and military arms confirms this understanding, as the weapons were one and the same. Another group's petition for cert before the Supreme Court threw machine guns under the bus, all but agreeing with the anti-gunners that laws like the National Firearms Act are constitutional. These lawyers are arguing that banning machine guns could possibly be allowed under the historical tradition of prohibiting the carrying of dangerous and unusual arms, then presenting evidence to demonstrate that machine guns have been historically restricted or banned because they're dangerous or unusual, all but conceding that machine guns are not protected by the Second Amendment. Our attorneys, on the other hand, are arguing that you have the right to fully automatic assault rifles because that's just what the founders intended. Hey guys, so while this video was being edited, the Supreme Court denied our petition to hear the case. But don't lose hope, because Justice Thomas and Justice Alito made some comments that this case may return to SCOTUS sooner rather than later. First, the denial was based on a procedural technicality. The current appeal is what's known as an interlocutory appeal. This specific type of appeal occurs when a ruling is appealed, but other aspects of a case are still ongoing. And so basically, the Supreme Court wants the Seventh Circuit to make a final decision before they review the case. Next, Thomas blasted the Seventh Circuit for contorting what little guidance the Supreme Court's precedents provide, and concluding that the Second Amendment does not cover militaristic weapons. And so for this reason, Thomas states that the court must provide more guidance on which weapons the Second Amendment covers. And that is exactly what GOA focused on in our petition for cert to the Supreme Court. Our attorneys wrote that the Seventh Circuit made no attempt to grapple with the uniform, enduring historical tradition under which no distinction was ever drawn between civilians and military arms. So this all sounds pretty promising for the future of our case. And lastly, Thomas refers to the dissent in Cargill v. Garland from Justice Sotomayor, where she refers to the AR-15 as commonly available. For those that don't understand this, the term common use is a protection for firearms under Heller. Thomas is cleverly using Sotomayor's own words against her to say that Illinois' ban on commonly owned semi-automatic firearms is unconstitutional. We're going to continue fighting this case in Illinois until we get a good ruling, or all the way back to the Supreme Court. We won't stop until this unconstitutional gun control is completely abolished. Thanks for watching, and we'll let you know as soon as there's an update in this case.